Hello, welcome everybody. Good afternoon on this first PilieroMazza webinar in the new year. Everybody's favorite topic, some of the cybersecurity compliance issues. Um, a lot of this, just to kick things off, there's some legal questions, regulatory issues that of course we're going to go through, and then we're going to touch on some of the other compliance matters. And a lot of these things are IT more related issues than really legal issues, but we're going to talk through those as well and talk through what we can and what we know of as of right now. But as I'm sure a lot of folks know, the new CMMC rules dropped, so we are going to touch on that at the end, but not really a deep dive. And then kind of see where things develop once the final rules come out. We're certainly going to put something out once those final rules are released, and sort of what has changed from the interim rules, and then also talk about and look at where things are going in the future. So with that said, I'm Alba. I'm a partner in our GovCon group and the current practice chair. And I'm here with my colleague, Daniel. You might recognize Daniel because he did the last cybersecurity webinar update that we did in the summertime. And I'm going to hand this over to him in a little bit. But as of first, people might know, or PilieroMazza, we are a firm that does, I think we try to hit everything that a lot of the mid-sized small companies need. In particular, we've serviced government contractors for many decades at this point. And so this is a little bit about us. Here, we're going to really get into cybersecurity in government contracts. And as everybody knows, the Biden administration in particular has pushed from the early days to make this a real priority. There's been a lot of fits and starts with CMMC 1.0 and then kind of 1.15 and then 2.0 and all these various iterations. And to me, it's felt a little bit like the boy who cried wolf, where the federal government has kept saying that there's going to be something with cybersecurity and 889, I'm sure you've heard 889 and the Chinese telecommunications and video surveillance equipment bans and the TikTok bans and everything else. And when is the government going to actually do something about this? And when is it going to be more than a legal requirement or regulatory requirement, but something that is actually a requirement that impacts you on your contracts, where you'll start losing contracts or getting removed from contracts and those sorts of things? We seem to be getting to that point, but I always want to put an asterisk on that because I think we've thought that for probably 6 years now, that this was going to be a real thing, but it seems to be coming to fruition this year and going forward in 2025, 2026, where a lot of the non-DoD agencies, I'm sure, are going to really start pushing a lot harder than they have. So a lot of these new rules coming out. There's some acknowledgement now that some of the requirements that they're going to force on even small businesses are going to be costly. I think the latest report I saw with some of the CMMC stuff was they're expecting it to be 150,000 to comply with everything. And that's on an annual basis, so not inexpensive. And so we'll have to see. We'll see where things go. There have been some FCA cases in the past year or 2 years that have come up where people have said they're compliant with DoD cybersecurity rules and they were not. So that is something that they are paying attention to. That was the sort of first round of enforcement. And today we're going to go through unclassified information and what you need to do to protect that. We're going to go through cyber threat reporting. We're going to go through the various exclusion orders. And then we're also going to talk about at the end some of the CMMC issues and what came out. I think once the final rules come out, we're probably going to do another presentation on CMMC issues, likely with some of the CMMC firms that we have worked with in the past and some of those IT CMMC consultants to help firms really implement the rules and not just understand what the legal requirements are. So that's what we're going to get into today. I think we're going to start with some of the unclassified rules. And Daniel, do you want to kick us off and start walking through this?
Yeah, thanks, Cy. Good afternoon, everyone. As Cy mentioned, my name is Daniel Figuenick. I'm associate here at PilieroMazza and in the government contracts practice group. I handle a bunch of different topic areas, but for the purpose of this webinar, I do have a slight specialty in cybersecurity and data privacy issues. So we can get started here. And I think before we jump into the unclassified federal information system proposed rule, I think all of these rules, as I was talking about, are very much aimed at helping try to protect the nation's data, which is just constantly under the threat of being attacked by bad actors with malicious intent. And so one of the proposed rules actually had an interesting statistic. The Council of Economic Advisors estimated that malicious cyber activity costed the US economy between $57 billion and $110 billion in 2016. So over a 10-year period, that burden equates to $570 billion and $1.10 trillion in costs. So these rules are definitely significant, and the impacts are, of course, felt by all. So with that being said, we can jump into the first proposed rule on unclassified federal information systems. So this rule and its proposed requirements only affects contractors that implement, operate, or maintain a federal information system, FIS, for the federal government. And so we've included the definition of a FIS as proposed by the proposed rule here. And you can tell it's pretty broad. A FIS is defined as a discrete set of information resources organized for the collection, processing, maintenance, use, sharing, or disposition of information that is used or operated by an agency, contractor of an agency, or another organization on behalf of an agency. And so for the purposes of this proposed rule, there are going to be two types of FIS. A FIS that uses non-cloud computing services, and the relevant FAR clause that's proposed is going to be that 52.239-YY that will be inserted into certain types of contracts and solicitations. And the second type of FIS is one that uses cloud computing services. And so if a FIS uses both non-cloud and cloud computing services, contractors will need to make sure they're complying with the relevant requirements from each of those clauses. And so currently, before this proposed rule came out, contractual cybersecurity requirements for these unclassified federal information systems were based on agency-specific policies and regulations that oftentimes resulted in inconsistent cybersecurity requirements across federal contracts. So this proposed rule seeks to provide a uniform set of requirements for federal information systems, and also propose two new contract clauses, as well as a new subpart in the FAR under Part 39. So we'll first start with the first subset of federal information systems, and that would be the non-cloud computing services ones. So agencies are going to have to identify the Federal Information Processing Standard, the FIPS impact level, for the relevant contract. And so the FIPS impact levels, these measure the potential impact on organizations or individuals should there be a breach of security, for example, loss of confidentiality, integrity, or availability of the information on the FIS. So the higher the impact level, of course, the greater the need for additional security requirements they're going to be. And currently there are three impact levels: high, moderate, and low. And generally contractors will need to limit access to and use of data, handle cyber incidents in accordance with this proposed FAR clause 52.239-CZ, which we'll discuss a little bit later on in this presentation, and permit government access to the contractor systems and facilities. And so the proposed rule does single out moderate or high FIPS impact level contracts, where contractors are going to need to take additional steps to protect their federal information system. And some of these steps include conducting annual cyber threat hunting vulnerability assessments, entering into confidentiality agreements with third parties to the extent that these third parties are conducting those assessments, and, as I already mentioned, permit the full and timely access for the government into your facilities and systems to review to determine whether the contract clauses and security controls are being implemented correctly. And so in addition, contractors are going to also need to apply some of the guidelines from various NIST special publications to each federal information system. And these NIST publications are going to be identified in the relevant contract clause, but they could include creating, reviewing, and updating a system security plan, which many of you already may know or already have. And agencies will also be able to specify other security and privacy controls that may need to be implemented outside of these contract clauses. So it's definitely something to watch out for.
Yeah, and I think to that point too, questions have come up about, what happens if we have a situation where there's a contract, the government decides that there's some sensitivity to the data because of maybe a modification, and the sensitivity level increases. Well, once that modification comes out, if there isn't a time period for compliance in that modification, then technically you'd be in breach of contract if you weren't compliant on day one. And there could be increased costs like we had talked about. And so that would create an REA scenario. So I would say just be aware when there are changes or policy changes, because I've certainly seen that in the past with some of the older rules where the government incorporated the rules and sometimes tried to treat it as a unilateral mod, or they said, well, no, you have to sign this or we're terminating the contract. In those sorts of cases, you should try to make the government do it unilaterally. And because therefore you're not waiving any rights. You could try to determine what your actual costs have been to implement a modification of any of these requirements, and make sure you're keeping close eye and careful track of what those are so that you can show what the exact impact has been. Certainly for the REA, because then you get direct reimbursement, or at least you're entitled to it. But also just generally, because I think with a lot of these rule changes, the government's going to want to know what the impact is. And even if it's just through essentially lobbying, knowing what those impact costs are would be important. And the government's going to mostly expect that these costs go in your G&A and your overhead costs, as opposed to direct costs, because they're going to expect this to be spread out, because the cybersecurity procedures you're implementing are going to be for the entire government. So just be aware of that as well, and keep careful track of things.
Great, thank you, Cy. So next is going to be the second subset of federal information systems. And these are going to be cloud-based computing federal information systems. So for contracts involving these, a different contract clause will be used, as mentioned a couple slides ago, but mostly the same requirements are going to apply. So the government estimates that based on the number of federal information systems currently offered, 56 different entities will be awarded a contract annually for the development, implementation, operation, or maintenance of a cloud-based federal information system on behalf of the government. So if you happen to be one of these entities, this clause will be material to your compliance with the contract. And so, like I said, most of the requirements are going to be the same. However, there are some notable differences we want to point out. So for these cloud-based federal information system contracts, the agency is going to identify the relevant FedRAMP level for the federal information system. And contractors will then need to implement and maintain the relevant safeguards in accordance with their corresponding FedRAMP level. They'll also need to engage in continuous monitoring activities and provide certain continuous monitoring deliverables. This is fairly standard practice, because once a cloud service provider has received a FedRAMP authorization, it's generally required to continuously monitor their cloud service offering to detect any changes in the security posture of the system. And one notable difference too is that if you're handling a cloud-based federal information system and the FIPS level is identified as high, Contractors are going to need to ensure that all the government data is maintained within the United States or its outlying areas.
Yeah, and I think there was a question we got at the beginning about giving some examples of FIS. And I know we have some clients that deal with, for instance, gathering and analysis of data and information for like a banking system, right? So it's the database where information is collected dealing with certain like Sarbanes-Oxley issues. When that information comes in and the contractor has this system themselves, but it's for use of analysis of compliance with certain things, that would certainly be a FIS in the way that I read the definition, because anytime you have a system that, and if the agency's operating it, you probably don't even care because it's their problem. But if you have a system as a contractor with your equipment and there's a set of resources, servers and whatnot that you are providing for the government, and there's either government data coming into it, or you're processing government data through it, or you're in charge of maintaining these systems, or you're taking information from a government system, running it through your system, and then pushing it out. That all of those sorts of things, and it's very broad, and so is the way that I would read it. But the government should be responsible for including the clause when they think it is appropriate. So it's similar to whenever you're dealing with CUI. Now, that being said, like CUI, there are certain instances where I think the government is misclassifying or not classifying it. And I think GAO did a report or an audit and found that some ridiculous amount of federal agencies weren't marking CUI. I think it was over 50% of the time they weren't marking it. And that's really, I think, the government's responsibility, but doesn't mean they won't hold you accountable. So to the extent there is a question about whether or not you are accessing or using, not really accessing, but you are running these systems where you're collecting data, processing data, maintaining data on behalf of the government, you're likely covered. But if the clause is not in your contract, then contractually, I don't think you're responsible for it. Secondarily, there was a question about dissemination of information in SAM. That I don't know. And I'm also not sure about the third question we got when it comes to CMMC training for government personnel. I believe they're going to be doing something. That is also my understanding from talking to folks inside the government, that the plan is to roll out trainings, but they're not going to do anything until there's the final rule, or they understand what the final rule is going to be. That is also what I've heard, but I can't say for as far as supplemental training beyond what they already have for the standard DFARS clauses. All right, so I just wanted to kind of go through those questions. Oops.
Thanks, Si. Yeah, so moving on. One of the more significant provisions coming out of these two contract clauses from this proposed rule is the indemnification language. So this language requires contractors to indemnify the government against any liability arising out of their performance incurred due to the contractor's potential or actual unauthorized disclosure of trade secrets, copyright materials, contractor bid or proposal information, source selection information, PII, CUI, etc. And so by signing the contract, contractors waiving their ability to bring suit against the government to recover damages resulting from such events.
And this is not dissimilar to the CUI clauses that I'm sure you've already had in your contracts for a while now, and you just might not realize it. But you're already saying, like, look, to the extent that there's breaches or the government loses data, there's liability protections on there for the government itself, and that you're responsible to compensate. So this is not exactly the newest thing, but they are strengthening it. I think making it more clear. Whether they'll actually go after it, because in the CUI context, for instance, if there's spillage of CUI, technically you're responsible for indemnifying the government for the cost of cleaning up the spill. But when you're talking about the internet, I mean, those costs could literally be limitless. It could be an infinite amount of money if you literally tried to clean the entire internet of certain data. If you think about Snowden, right? You could literally spend an infinite amount of money and never clean it up. So I'm not sure exactly what they're going to do here or how far this is actually going to get covered. It's more a tool the government can use, I think. If a very large company has a major breach, I would imagine they're going to seek serious damages. Whereas for smaller companies, I'm not entirely sure that would actually be the case.
Yep. So I guess some of the next steps for contractors, if you're on if you're performing a contract or handling, operating, maintaining one of these federal information systems that Cy clarified the definition on, gave some examples of. I think first step obviously is to determine if you are operating a federal information system. And it's going to take some time to review this proposed rule and potentially comment on some things that you may want to see changed in this proposed rule. After you determine whether you're operating a FIS and the contract has this contract clause in it, it'd be best to understand whether it's a non-cloud or a cloud computing services federal information system. You're then going to want to review some of your current cybersecurity policies, safeguards, security, and privacy controls that are used to protect the data in the federal information system, and compare those policies with the requirements in these respective contract clauses to determine compliance. And as I was discussing some of the expected costs, estimated costs regarding CMMC, well, for this proposed rule, for those contractors that are going to be affected, the FAR Council estimated that it's going to cost hundreds of thousands of dollars each year in order to comply with the relevant contract clause and properly operate a federal information system, whether that be cloud-based or non-cloud-based, because it is going to take some time to understand some of the, the nuances of the requirements in these rules and the clauses.
Which I always think is interesting too, because I'll talk to some clients who will say just that. You know, this is a lot of money, and it's going to be difficult for us to do this because we're, you know, whatever, we're a janitorial services contractor. Sure, we hold certain information like potentially schematics or blueprints, right? And that could be covered, and this is going to be really expensive, and it's not something we build into our rates. And then I'll talk to another client who will say, this is like nothing. These are really standard, like some of the NIST 800-171 controls. We'll say, this is all really standard. And I find it always challenging when people talk, well, what does this mean? Because the IT professionals out there, I would say rely on them and their good faith judgment as to what a particular control requires you to have. And unless there's cases on certain things that people had X and it wasn't enough, from the law's perspective, you look at a reasonable judgment of someone in the particular industry, and it seems to be widely divergent right now. And it's been like that for years. So possibly when the CMMC rules come out and they're finalized, we might see some more of a conjunction of opinions, but as of right now, it's still pretty broad.
Great. So we're going to move now to the second proposed rule of the webinar, which generally deals with some of the reporting requirements and information sharing requirements when a certain cybersecurity incident occurs. And note that this rule is intertwined with the former rule we just discussed, because the former cites these this contract clause right here, FAR 52.239 -ZZ. So the former, the -ZZ clause, contains requirements regarding cyber threat incident reporting, while the latter clause, the -AA, contains some of the requirements for contractors to certify that they are actively and timely reporting security incidents and flowing down these requirements to subcontractors. Now, I know I mentioned the number of entities that the FAR Council estimated would be operating those federal information system related contracts. It was about 56 per year for the last rule, so not as widespread or applicable to many of you, but this one is a little different in the sense that this proposed rule and these contract clauses are going to impact all contractors awarded contracts where there is ICT being used or provided in the performance of the contract. ICT is information and communications technology. It's IT equipment and systems, technologies, processes. And the FAR Council estimates that 75% of all entities awarded federal contracts have some form of ICT that they're handling, operating, or containing on their contract or their systems. And so the requirements for both of these clauses are triggered when a security incident occurs, which is an actual or potential occurrence of these events that we've listed below, pulled from the proposed rule. And as you'll notice, this definition is quite broad, especially considering the fact that it doesn't have to be an actual occurrence of one of these events. It just has to be a potential occurrence, which complicates things a little bit. So this next slide contains some of the key reporting requirements that all contractors with this ICT will need to abide by when a security incident occurs. And these obligations largely flow from that -ZZ contract clause mentioned on the previous slide. So for security incidents affecting products or services, contractors are going to need to immediately and thoroughly investigate all indicators that a security incident actually occurred. You're going to need to report to the Cybersecurity and Infrastructure Security Agency, CISA, within 8 hours of the security incident actually or potentially occurring. And there's a form on there that you'll be able to, there's a link in one of our recent blogs that you can click and find. It's fairly simple to search online too. You're also going to need to notify your contracting officer and the contracting officer of any agency who may have placed an affected order under your contract. And notably, this report that you submit to CISA, you're going to have to update it every 72 hours until all eradication or remediation activities have been completed by the relevant parties who are investigating the security incident, be the contracting officer, the FBI, CISA. And there is a special form for malicious computer software through CISA, and with the same reporting requirement within 8 hours of this actual or potential security incident.
Yeah, and these are always tricky. It's similar to like 889. The other things that say you have to do it within 24 hours, or here is 8 hours. And people always ask, well, when do I know there's been a potential breach? And that's where the requirement to immediately and thoroughly investigate kind of comes into play. And I think what we're going to see is if there is some breach of a relatively severe level, this is all going to be an after the fact thing, Monday morning quarterback, right? DOJ, potentially, if you didn't have things in place, or if the government feels that you misrepresented something, it would be DOJ. It could be just CISA if it's not some sort of nefarious issue where you misrepresented yourself. If it was just a breach, then on those sorts of situations, I could see them coming in and still wanting to know, well, when did you know this occurred? And if you have these systems in place the way you're supposed to, I would imagine they're actually going to use that against you if you delay. Because if you have all these cybersecurity methods in place where you're tracking, let's say, the packets that are coming in and out of your systems, let's say, then you should know pretty quickly whether or not something occurs. And depending on where they land with some of the CMMC stuff, you might have to have active monitoring of your systems, depending on what level you're at. And if that's the case, you really should know when something is someone from outside the organization or unauthorized individual has gained access. And it's not about immediately and thoroughly investigating the impact of that. It's, has it occurred? And within 8 hours of you knowing or believing or having reasonable judgment that it's occurred, boom, you have to act. So I'm curious to see what actually happens here and how many people actually comply, because I know with the 889 24-hour notice, there was a lot of hemming and hawing about, well, when do I actually know that something really occurred? Or when do I know it's possibly occurred? Maybe there's some wiggle room there. But I think if there's a lot of delay, from my experience with DOJ, they will use that against you and say, if then you either didn't do it on time, or if you did it within 8 hours of when you really knew, you must not have actually had the proper security systems in place. Otherwise, it wouldn't take you so long from the actual breach to the notification. So just be aware of that as well.
Great, thanks. And so, yeah, moving on, and very closely related is, after the fact, after a security incident occurs, it's the response that this rule also focuses in on. So like I said, the contracting officer, CIS, or FBI can request any relevant information after that security incident initially occurs. Contractors are going to need to respond to these requests within 96 hours, provide any information or equipment for forensic analysis by those entities, and to the extent the contracting officer didn't request this information, you're going to need to notify them upon a request being made too. And so regarding data preservation, contracting officers can request data at any time, really, and the delivery to the contracting officers must be prompt for them to investigate the security incident. This data should be preserved for 18 months from the security incident occurring, and at a minimum, and during the contract, and at least 1 year after, the contractors must develop and maintain a collection of customizations that may differ from the manufacturer defaults. For example, software that you've customized, they're going to want to have some sort of log or data that describes those customizations. Some of the examples of the types of data that should be preserved: network traffic data, full network flow, perimeter defense logs, and full system logs are some of the examples the proposed rule gives for data preservation.
Yeah, and I'll also note too, this is where whenever we've gotten involved in breach issues, you want to make sure that the counsel, the lawyers you're using are involved early, because if you get let's say you have a consultant that does, CMMC compliance, or a consultant that does like penetration testing and also analysis of a breach, any correspondence you have with that consultant is all discoverable. And any communications you have, or if the consultant says, hey, we just took a look, we realized there was a breach and they got access to this, and we think it's because of, you didn't have whatever. All of that communication is discoverable information, and if they ask for it, you have to turn it over, or if there's a further investigation, it gets subpoenaed, it's all going to have to be turned over, of both you and potentially the consultant you're working with. Now, if before the consultant starts to dig into everything, if you work with counsel and counsel hires the consultant instead of you hiring the consultant, and most of the time, if any good counsel is just going to pass that through, and they're not going to put a load on it or anything, it's just going to, the cost of that is going to be, you just pass directly through to you. And then any communications about whether or not Do you have to report? Was this actually a breach? Why did it happen? You want that investigative process to go through counsel, because then it's arguably all that information is being gathered for the purpose of giving legal advice, which makes it protected information. It's immune in most cases, if it's actually for legal advice, from subpoenas or from unauthorized access. And then there can be a report prepared that is for you as the company, which can be attorney-client privileged, and then a separate one that's going to the government, or if they're seeking information, things can be sort of vetted as to what's necessary to be given. So just remember that as sort of a prophylactic measure. When things happen, you have to move pretty quickly. It can be very, rushed, but to the extent that you can have, or you already have counsel to get them involved, it can be certainly a protective measure.
Yeah, so as I mentioned at the start of discussing the second proposed rule, not only does it kind of hone in on some of the reporting obligations that we've already talked about, but also some information sharing requirements during the performance of the contract. So this is going to enable these requirements are going to ensure that there's timely responses are made to the government, but also to ensure timely prevention, similar security incidents occurring elsewhere and affecting other companies. So the clause requires you to either subscribe to an automated indicator sharing service during contract performance, or participate in information sharing with an ISAO or an ISAC. So the AIS option, and I believe a link can be found in the proposed rule itself. It uses a sort of server-client architecture for communications, where participants, the contractors, can connect with a server to exchange these certain indicators, cyber threat indicators, and defensive measures with CISA. And these submissions are going to be anonymous. Instead of interacting directly with CISA, you can choose the latter option and just share your cyber threat indicators and defensive measures put in place in response to the security incident through one of these participating ISACs.
Yeah, and you don't want to hide things for sure, because if it goes beyond an investigation, the implications are far worse than just breaching your contract because you didn't have a particular issue. Then at that point, that's where you get into FCA matters. I think the tricky thing for companies is there's nothing stopping the government from retroactively saying, okay, you self-reported or you told us about something, then we know you didn't have the proper controls, therefore it was a breach of contract and you weren't compliant, or even worse, there was some sort of false claim because you knew or you should have known because you recklessly disregarded the truth of the matter that you weren't compliant. That's certainly possible. And so I think companies sometimes roll that dice. I think legally you have to respond to provide the information right away. Obviously, that's what we just talked about. I think some companies decide not to do that and kind of put their head down and hope someone finds out. But if someone finds out, it will be way worse for you. So just be aware of that.
Great, yeah. And so one of the contract clauses, the -CZ, does require contractors to develop and maintain a software bill of materials for each piece of computer software used in performance of the contract. And it requires that the minimum elements of an SBOM be included, but of course the agency could acquire additional elements if they see fit. And I've listed I've listed the 3 minimum elements of an SBOM on the slide. And the emphasis on SBOMs it really has been a government-wide effort, and we've been covering some other developments too that have been happening this past year in 2023. Over the summer, CISA had released a common draft form that's still in the proposed stage that will require contractors to obtain certain representations and attestations from their software developers, software producers, to ensure that those companies, those entities, are complying with the specific NIST special publications 800-171. And In addition, just last month, the National Security Agency released a cybersecurity information sheet with recommended practices for developing SBOMs and choosing the right tool to help create an SBOM, applicable to both contractors and the government, recognizing that, it really does take two to tango. You need both the contractor and the government utilizing the correct tools to ensure that these SBOMs have the relevant information in the data fields and are in the correct format, allowing for the automation support. So yeah, and we will be probably releasing a blog shortly regarding that cybersecurity information sheet, because it does have some helpful information regarding the development and use of SBOMs. So we've been talking mostly thus far regarding this proposed rule about the first contract clause, the 239-CZ. Well, this slide really focuses on the second clause. It's much shorter. It's the 52.239-8A. And it largely contains reporting, certifications, representations, and flow down requirements for the prime contractor. So contractors are going to have to represent their compliance with that first clause we've been talking about, and certify that these requirements are being flowed down to the lower tier subcontractors. Offerors are going to have to represent that all security incident reports have been submitted in a current, accurate, and complete manner to CISA, and any subcontractor using or providing ICT will need to also abide by that 8-hour reporting requirement to CISA, and include that requirement in every lower tier subcontract. So interestingly, this clause, unlike other current FAR clauses that are in the FAR in Part 52, this one specifically and expressly requires obligations be flowed down to subcontractors potentially several tiers below that first tier subcontractor. So, and yeah, just a brief summary recap on some of the key takeaways when one of these security incidents occur. You got to report your security incidents within 8 hours of discovery and update that report every 72 hours. And like Sai said, you might as well do it as fast as possible, as soon as possible. It can't hurt. You're going to want to stay abreast of all the threats and be prepared to share any indicators with any of the relevant parties that request information. Noted that 96-hour response time. You might as well try to respond as quickly as possible to those requests for information. You're going to want to develop any policies, processes, and procedures to the extent you don't already have them in order to implement some of these requirements. And failure to comply with some of these requirements, especially those representations in the latter contract clause proposed by this rule, will and can result in False Claims Act liability.
Exactly.
All right, so moving on to the third one, this is a little bit shorter, not as much involved as the first two. It is an interim final rule, and it took effect on December 4th of 2023, and it primarily deals with ensuring certain goods and services that are deemed prohibited by certain agencies and councils are not used or provided during the performance or procurement of government contracts. So here are some key terms up here. Federal Acquisition Supply Chain Security Act of 2018 is going to be FASCSA, and the Federal Acquisition Security Council, FASC. So FASC has the ability to issue these recommendations to agencies to exclude certain goods or services from procurements that may pose certain risks to the supply chain. And agencies will then, based on these recommendations, they can issue FASCSA exclusion orders, which require that the covered goods or services be removed from current contracts and prohibited from being provided in future contracts. And so these aren't agency by agency exclusion orders. So there's a few different categories. So there's DHS. If they issue an exclusion order, it applies to civilian contracts. If the DoD issues one, it'll apply just to DoD contracts. And if the Director of National Intelligence issues one, it'll apply to all intelligence community agencies, like the NSA, the CIA, the NRO, just to name a few. And all three of these bodies can issue a joint exclusion that would apply to all contracts government-wide. So how to find these FASCA orders? The proposed rule discusses searching them in the System for Water Management, SAM.gov, and simply searching FASCA order. I think if you try this, you'll notice that not just FASCA orders will populate. I haven't seen any yet, but I did notice that certain contract opportunities do populate because they have the FASCA order clause, contract clause in the body of the SAM.gov profile page, so they might need to fix that. But if they're not available in SAM, the contracting officer is supposed to list any applicable exclusion orders in the solicitation. And contractors must conduct reasonable inquiries into their supply chains to determine whether they are providing any covered products or services that should be excluded. And during performance, contractors are going to be required, if they have FAR clause 52.204-30 in their contracts, they will be required to search SAM.gov every 30 days for these exclusion orders to ensure that they're not providing or planning on providing any covered articles or services.
Yeah, and this too, we always get a lot of questions, whether it's 889 or something like this. When is it updated? How do I know? There's so many different lists out there that all seem to have the same language. I think there's also some interpretations from folks that certain lists that aren't directly related to this, but have a very similar exclusion like language, it might still apply. But I think to make it as simple as possible, I would say keep up with what Daniel just said, and try to make sure that in procurements that the government starts to do this, because I have a feeling they're not going to list everything, but you're still responsible for knowing what's in SAM when it's there. In fact, anything in SAM is considered to be an official source, and if there is something in SAM you're considered to have known or you should have known, which comes back to the potential false claims issue. If there is the list in SAM that you should have known about because it was sitting there and you didn't, then if you're later found to be using some of these things, then it can be a violation there. So just, again, you have to make sure you're keeping up on things. You're checking in SAM. What's the latest and greatest, and most likely when these clauses are in there, I'm sure the government will have provisions in RFPs that will sort of say you have checked this. And the reasonable inquiry standard, I think, is similar to 889 in all of these requirements, that you've gone through and you've checked, you've asked. Like, for instance, if you haven't even tried, you know that's not really a reasonable inquiry. And if you're in any sort of M&A situation, down the road, you're trying to sell your company, I can guarantee you this is going to be something that's asked, and they're going to likely take a purchase price off the table if you can't show them that you've made a reasonable inquiry and explain what you did as part of that process. So that's just another piece of the puzzle.
Yeah, and to the extent you need one of these goods or services and you need to provide it to the government, there's only one, and you anticipate that it's going to be covered by an exclusion order or it already is, you do have the contract clause does allow you, in the FAR now, does allow you to request a waiver. And the contracting officers do have broad discretion to pursue a waiver to one of these FASCA exclusion orders. We've provided some of the information that needs to be given to the CO when asking for one of these exemptions. And it'll be very important to provide all of this information with a requisite level of detail to increase your chances in obtaining a waiver in a timely manner. Ensure that they're not just sitting on it and processing it timely. And so certain obligations are going to arise if during performance an exclusion order is released and you discover through one of your reasonable inquiries through a subcontractor, they've identified that they have provided a covered good or service by one of these exclusion orders. So once that occurs, you're going to need to submit a detailed report with the same information on the previous slide to the contract officer within 3 business days. And like we said with the previous rule, it'd be best to try to submit it as soon as possible. Additional information is going to be required to be submitted within 10 business days regarding any mitigation actions you've taken to exclude it already from your supply chain. And the contract officer can request that the contractor promptly make any necessary changes or modifications to remove any of these covered goods or services from its supply chain. That is, if the exemption process fails.
Yeah, and I think, well, actually, we'll get to it at the end. Just keep going because time.
No problem. Yeah, this last slide on the
do it next.
Ask exclusion orders. So I think it's just some of the next steps to ensure you're complying with these. Is compliance is key. You know, failure to comply could result in contract termination because these requirements are going to be included in the relevant FAR contract clause that I mentioned previously. I think it would be important to develop internal policies and procedures for self-identifying whether you've been providing a covered good or service by one of these FASTC exclusion orders, and ensure you have the correct procedures for reporting to the government when you have been providing these services. You're going to want to regularly conduct inquiries into your supply chains. Ensure your subcontractors are doing the same to avoid that False Claims Act liability. And at a minimum, constantly review sam.gov for any potential exclusion orders and your solicitation, which may include exclusion orders that are not listed on the SAM. And Si, did you want to talk about the last rule, or are you okay?
Yeah, I guess, well, the one thing I wanted to note is that the question too about, we had a number of questions about some of the cost stuff. And I think the way they're going to treat the cost increases is if it's a new contract that's being awarded and it's not a modification to an existing contract or task order, then those costs I think are going to be treated as G&A costs. They're not going to be treated as direct compensable costs. Now, if there's a modification to a contract, or if there's a new task order issued, or an amendment to a task order, something like that, that adds the requirement, and it wasn't part of the original contract itself, then I think there would be a basis there to file an REA to request a direct increase to the cost for that particular contract. It gets a little tricky though, because I think it would still have to be some form of increase to the G&A rates. And if it's a firm fixed price contract, it would be some sort of fractional amount, which would also, I think, be difficult to try to convince a contracting officer, because if it's not your only contract that requires this, and if you're a government contractor, it's all going to start requiring it, so it's just a matter of time, then it would not be a direct cost to the contract unless, again, it's your only contract. If it's your only contract, you might be able to make the argument that this cost increase is for this contract only. I have no other reason to update my systems. Or for instance, if you have completely separate systems and for one particular contract, you have to have a separate segregated system set up that has to have all these other controls, and it's completely separate and apart from what you use for your business generally, maybe there's an argument there as well. that you could seek direct increases. Otherwise, I think this is something whether the government said this $150,000, that's something that's going to have to be built into your general overhead as a government contractor. That's just what your systems are going to have to be now, and it's going to have to be baked into your firm fixed price costs or your G&A if you're a cost reimbursable contractor, et cetera, et cetera. And it's something that's going to have to be checked on. So just be aware of that as well.
Great. So, and lastly, we did say we'd touch on it, albeit briefly, and it's not the entire focus of this webinar, but the new CMMC rule, which was released just before Christmas. It rolls out the proposed CMMC program. Comments on this proposed rule is on the longer side, are due, as of now, they're due February 26, 2024. That may be extended, but there'll be a notice if it does get extended. So the CMMC program is going to be codified in that Title 32 of the Code of Federal Regulations of Part 170. And a new rulemaking is going to be required to actually implement it into the FAR, roll out some FAR contract clauses, which is expected in March 2024. That obviously could slip. I think one of the first things that jumped out regarding the CMMC rule is that, or we've seen it in some clients' contracts already over the past couple of years, is the DoD DFARS CMMC clause at 252.204-7021, which does require contractors to have a current CMMC certificate at the CMMC level required. Obviously, they were preemptively getting ahead of themselves by including this contract clause without the actual program being rolled out yet or implemented into CFR. But unfortunately, I wish we could have better information for you, but many commenters on the last proposed rule asked about this clause and its effect and its applicability to this proposed rulemaking. And the DoD just repeatedly stated that the CMMC proposed program in the rule was going to be implemented in the DFARS as needed, which may result in changes to the current DoD solicitation provision and contract clauses, including this clause on the screen right now. They were unable to address the applicability of or changes to this current clause, unfortunately, so it appears a separate rulemaking will be needed to either amend this clause or add additional clauses to actually implement it into DoD contracts and the FAR.
Yeah, it's really kind of ridiculous.
And like I said, a brief overview. There's three major features of the CMMC program versus this tiered model, which many already likely know about. Companies that are entrusted with national security information are going to need to implement relevant standards and safeguards at progressively advanced levels 1, 2, and 3, depending on the type and sensitivity of the information being handled under the contract. The second tier are going to require assessments to occur at various times. So assessments will be needed at the various tiers to ensure contractors actually have the appropriate security controls in place to protect the sensitive information that they're handling. And as a lastly, implementing these requirements into contracts as a condition of contract award, contractors are going to need to have the requisite CMMC level. But as I mentioned just a second ago, the actual proposed rulemakings for implementing into the FAR and DFARS are yet to have been released. So, and finally, and interestingly, there is a timeline in the proposed rule that DoD gives. And well, I mean, while the proposed rule is helpful for many, and it includes those various guides and assessment guidance that were released along with the proposed rule, there is still definitely a ways to go before the contractors actually begin to substantially be affected by the CMMC program. So you'll see the DoD intends to introduce these requirements and solicitations over a 3-year ramp-up period. They anticipate that will take at least 2 years for companies with existing contracts to become CMMC certified. The DoD intends to include these requirements for all 3 levels in solicitations issued on or after October 1st, 2026, in almost a little under 3 years from now. But you should note that in the interim, the DoD program managers can and do have the discretion to include these requirements in accordance with certain DoD policies.
Yeah, and I think there was another question before we, I know we're out of time, but a question about the intention to roll some of this out beyond contracts into grants, OTAs, that kind of thing. I think with grants, it's probably going to get there. Same thing when it comes to, I mean, this is CMMC is all DoD stuff, but it's going to come to civilian agencies, and I think in probably relative short order. Although, heck, CMMC took so many years to finally get here, and supposedly going to get here this year, but we'll see. And then from there, it's going to take some time for the civilian agencies to adapt it. I know the VA and some of the other agencies have taken steps. So I would say it's inevitable that this is going to be rolled out likely to everything the government pays for. And I could even see it slowly rolling out beyond that. And then when it comes to some of the OTAs, I would suspect that DoD in particular are going to adopt some of these clauses, if not just include the clauses. I know their FAR doesn't directly apply, but I'm sure if any of you have worked on OTAs, you've seen that a lot of the OTAs have FAR clauses in them because it's just easier to take them and say, oh, by the way, we're including this, you have to comply with it. So I would suspect that requirements like this or the FAR clauses themselves will also be included there. And so we'll just have to see where things go, but that's my guess, my crystal ball. I know we are out of time on things, and there's some questions we didn't get to, but we'll certainly follow up with folks. And if there's other questions that come up in the meantime, or if you want something in particular answered, this is our contact information. So, happy to talk to folks or answer anything. So thanks again for coming out for this first webinar of the year, and
Thank you, everyone.
stay tuned to what we put out in the not too distant future as well, and some of our blogs, and I'm sure we'll do more of this in the future. Thanks, everybody.
Great. Bye.